You think a green card means you're safe. It doesn't. One conviction, one mistake at the airport, or one issue buried in your past can put you in immigration court fighting to stay in the United States and save your green card. If you stay with me, I will reveal what is perhaps the most stupid reason to lose your green card later on in this video. Now, when a lawful permanent resident ends up in immigration court, the green card is not automatically gone. A judge can take it away only if the government can prove a legal ground of removability under Immigration and Nationality Act. Here, I will show you 7 of the most common reasons permanent residents lose their green card in removal proceedings. Number 1, aggravated felony convictions. This is the most serious category. Advanced felony is a technical immigration term. It includes many offenses that are not necessarily aggravated or even felonious under state law. Certain theft offenses, fraud involving more than $10,000 in losses, drug trafficking, crimes of violence with 1-year sentence, and sexual offenses all fall under this category, or they can at least anyway. If the government proves what you're convicted of is an aggravated felony, the person becomes removable. Most forms of relief are barred for those people who have an aggravated felony charge or conviction, The judge has very limited discretion. The conviction record is what controls here. Immigration court does not retry the criminal case. You can't go back and say, well, this was the reason, the other thing was the reason. You can't. Number 2, crimes involving moral turpitude, or CIMT as we call it. A green card holder can be removed from the United States for one CIMT, or crime involving moral turpitude, committed within 5 years of admission if the offense carries a potential sentence of 1 year or more. 2 CIMTs at any time not arising out of the same scheme also would have the same effect. Crimes of moral turpitude often include theft, fraud, certain assault offenses, and crimes involving intent to harm or deceit. These are cases that are highly technical. The immigration court is where you will have to duke this out, and your immigration attorney is so valuable in this instance because all of these cases are subject to interpretation. They can be argued out, and this is not the sort of thing that you should fight it alone. I suggest very, very strongly, if you've been hit with a crime and now you're in immigration court, to definitely hire an attorney, hire somebody who's an expert at immigration deportation cases and can help. Now, number 3 is controlled substance violations. Almost any controlled substance conviction can trigger removability. Even a minor drug possession offense can place a permanent resident in proceedings. The narrow exception is a single offense of possession of marijuana, which is less than 30 grams, that could be knocked off. Drug trafficking offenses are especially severe, and also many of them qualify as aggravated felonies. So this is something you have to be very careful. Number 4, fraud or misrepresentation where you were getting your green card. You got your green card by fraud or misrepresentation, basically. If the government proves the person was not lawfully admitted for permanent residence because of a fraud or material misrepresentation, the green card can be rescinded through removal proceedings. Now, intentional misrepresentation of a material fact. Here, if you have a good attorney, the attorney would fight the fact that it wasn't intentional. It wasn't a misrepresentation. The fact wasn't material. Had this been divulged in the first place, you would have still been able to get your green card. So this is a highly technical area, and this is something that you're not going to be able to handle yourself, most probably. So I suggest very strongly you have an attorney help you. Some of the examples of this intentional misrepresentation of a material fact. For example, marriage fraud. Marriage fraud is, if proven, almost always irrecuperable. There is nothing else you can do about it. Concealing prior immigration violations. Hiding criminal history that, had it come out, you would not have gotten your green card in the first place. Using false documentation. The key issue is materiality. The government must show that the misrepresentation was in vain of a sort of thing that, had they known, you would not have had the favorable decision that you had in getting your green card. Now, abandonment of permanent residency is number 5 in this instance. A green card allows you to remain in the United States, and if you are using it just as a safety valve to live in your own home country but have it just in case something happens, that's not going to work. There are legal requirements for you to be living in the United States the majority of the time to be able to maintain your green card. I have a lot of clients who think that if they come back every 6 months, they will be fine. That's not the case. And you have to show that within any given span of time, you have lived the majority of it in the United States. There are technical ways of doing this. And again, this is the sort of thing you have to speak to an attorney if you feel you're in that segment of the green card holder population. The government can argue the person abandoned the residency if you're not here for extended periods of time. Length of time abroad matters, but intent is even more important. The judge is going to look at the totality of circumstances. Do you have a home here? Do you pay taxes? Do you have family ties? Do you have employment here? And all of these things. Now, number 6, failure to remove condition. This is the one that I was telling you is, as far as I'm concerned, the most stupid way of losing your green card. A lot of clients come to me, a lot of people come to me to become our client that have failed to file for the removal of condition within the 3-year period. There isn't anything you can do. You have to go back unless it was excusable for some reason, and it was the delay was, you went over the 3-year period by a very small margin, and there was a really, really good reason, which is rarely the case. Then you have to go back to the bottom of the hill and refile again for your green card. Now, in the meantime, you have run out of status because you no longer have the conditional residence, so they can put you in immigration court proceedings. If USCIS denies the I-755 and terminates your conditional status, you can be placed in removal proceedings in the court in front of a judge. And now, sometimes the I-751 is denied because the government thinks you have not shown that this was a bona fide marriage. Now, in front of the judge, you can actually show that this was wrong. If you have an attorney, they can represent you well in this instance. If in fact lack of documentation has good reasoning and this was a bona fide marriage. If the judge is not convinced the marriage is bona fide or no waiver applies, then you lose your green card. And number 7 is security related or terrorism related grounds. This is less common, but it's an extremely serious case. A permanent resident can be removed from the United States for terrorist activity, for providing material support to certain organizations. I have a lot of clients from Iran who had to serve their mandatory army duty with the Sepah in Iran, the IRGC. It wasn't voluntary, but nonetheless, because of their service, their national service, now they're in trouble because the US government is trying to deport them, despite the fact that this wasn't voluntary on their part. Espionage or sabotage is another reason that falls under this category. Certain foreign policy grounds dictate what the US does here. These cases often involve classified evidence, and they have complex statutory definitions. Now, an important reality. A green card holder does not automatically lose status when charged with removability. The Department of Homeland Security must prove grounds by clear and convincing evidence in immigration court. So this is where an attorney is your best friend. Then even if removability is proven, the person may qualify for certain reliefs. For example, let's say you can be removed from the United States, but you can file for cancellation of removal, or there are waivers available in your case. All of these I will explain in other videos. Or you can adjust your status in certain limited situation. Immigration court is where the green card is formally taken away, but that's after the judge issues an order and after a lot of litigation. I hope this video has been helpful. Call us if you have any questions. Thank you.